Hello and welcome to the Disability Law Q&A with me, Martin Willemse. I'm a partner and Western Canada disability practice leader at the firm of Samfiru, Tumarkin LLP. We've got offices in BC, Alberta, and Ontario, and we represent people with disability claims throughout Canada, other than in the territories and Quebec. Please send your questions to us via social media platforms, and I'll get to them, hopefully all of them, in the time that we've got today. First one is sent by Yusuf. It says, the insurance company keeps sending me for assessments many times, and all those assessments saying must have translation or doctor that speak my language, but the insurance company refuses. What do I have to do? Well, one would think that in order for the insurance company to get an assessment on which they can rely, that they would have to have a doctor who would be able to either speak your language or for you to have somebody who is a translator or interpreter present so that the communication between you and the doctor would be accurate in order for the doctor to make an assessment. Lots of times when these assessments are done, the doctors do interviews. So what we're talking about is an independent medical assessment, I'm assuming, which would be where the insurance company will send an insured or a prospective insured to a independent medical examination, which really is a assessment that the insurance company pays for, and where the doctor who they retain, I suppose if you want to call it that, does an assessment. And part of that assessment is where the doctor interviews the person in order to provide or to gain the facts and then provide an opinion. So the insurance company is not doing themselves a favor in this instance if they are refusing to provide you with an interpreter, or at least a doctor who can understand the language that you are speaking. I would insist on doing that with them, and I would also insist on having them put in writing their refusal to provide you with an interpreter, so that if the assessment turns out not to be in your favor, and if there were to be a legal claim later on, then you do have that in writing. But I would insist that they do so. If you don't get them to agree, speak to the case manager's manager and elevate it up the chain of command, because I do believe in your situation, it really does make sense to have an interpreter present, or at least to have a doctor who speaks your language. I have a message from Ron20s who says, my sister is struggling with a serious mental health condition. The insurer has been putting up roadblocks. They are saying she has to provide more documentation. What is the best for her to provide? She has seen multiple specialists. First things first, if it is a mental health condition, and if you're saying to me that the insurance company is putting up roadblocks, it might be that they're not approving the claim or that they've denied the claim. If they have denied the claim, make sure that you do not miss the timeline, specifically to pursue a legal claim as well. Your sister is also welcome to contact us directly, and we can offer to her a free consultation. But considering what you've just said in your email to me, or the question that you've posed, what is the best evidence? When you have a mental health condition, these can become tricky. So what you want is to provide the best evidence that you can to support the claim that your sister is disabled. For example, many people have depression. Many people work with depression. Why is it such that your sister, whatever the mental health condition is, cannot work? So what needs to be done is you need to detail the restrictions and limitations, and that needs to be done by the doctor. For example, identify what the diagnosis is or the diagnoses are, detail what the restrictions and limitations are. For example, it may be inability to concentrate, panic attacks, inability to leave the house, poor memory, poor focus, oversleep, undersleep. If she's taking medications, how those may impact her ability to function cognitively. That she may have profound fatigue, she may have poor motivation, anger outbursts, emotional outbursts, physical manifestation of anxiety symptoms, etc. Then also discuss what the duties are in relation to her occupation, and then conclude as to why she is unable to work because of those restrictions and limitations to perform the duties of her occupation. We mentioned that she's seen many specialists. It might be helpful to have the specialist weigh in as well. They also will have to focus on the fact that hopefully she is seeing the doctors regularly and that she is following recommended treatment advice. If she has done various treatments and they have not worked, then the doctors can identify that. If she has had increased dosages in the medications, the doctors can identify that as well. All of this is done to focus on the fact that because of all these issues, she's unable to work and the medication may not be helpful, or if she's in treatment through counseling, that is still a long road, whatever the situation may be. So to put it in context, what needs to be done is you need to provide, or your sister needs to provide, as much supportive evidence as she can. And if she's got various doctors weighing in on this, letters from those doctors identifying what the restrictions and limitations are, because a disability claim is very much focused on functional impairment versus the diagnosis itself. Of course, the diagnosis is important, but when you get to mental health claims, be it because of depression, anxiety, PTSD, complex PTSD, bipolar disorder, whatever it may be, mental health is rising in this country, and it is the main driver for disability claims in Canada. Lots of claims are submitted, not all of them are approved. So if you do want to get yourself the best opportunity, you need your doctors to outline why it is that you are unable to perform the duties of your occupation. It's different from employment, right? When you've got an employment case and the doctors just simply write, my patient has a medical condition and is unable to work, where the employer may accept that. With a disability insurer, it's entirely different. The duty is on the person making the claim to prove that they have a disability. And that what that means is that they are disabled within the meaning of the policy. In other words, that they cannot perform the essential duties of their occupation because of an illness or an injury. Lastly, I will say, Ron, if your sister has any further questions, as I've said before, we do offer free consultations and we can assist by at least having a discussion with her, and she can make an informed decision as to how to proceed if a claim is denied. As you can see on the screen, you can go to disabilityrights.ca to get to our website, and if you've got want contact details, those would be in there as well. Then we have a question on YouTube from Kaylee K. I would like to return to work for my mental health and activity, but will only ever be able to do so on a part-time basis because of my disability. Because I won't ever be able to earn a full salary, will I still receive a portion of my LTD to top up my income? It's a very good question. It's a very difficult question to answer. Back to basics. Your disability benefit is paid to you pursuant to a policy, which is a contract. In the contract, there are various definitions. There are various obligations and rights as well. You have to fit within those obligations, those definitions, to prove that you remain entitled to benefits. If you do return to work, and I understand why you would want to do so, because of your mental health, that you feel it may be better to go back to work, which one would expect. But in certain instances, people are not able to do so. But if you feel that you've gained some traction and you can go back to work on a part-time basis, there are generally two definitions in a disability policy. The first one is the own occupation phase. The next one is the any occupation phase. During the first occupation phase, if you're able to work on a part-time basis, the employer may still top you up depending on how much you're able to work. When it gets to the any occupation phase, things become more tricky. There you have to prove that you have a disability that is both preventing you from performing the duties of your own occupation, but also any other occupation based on your transferable skills, and this is the important part, that would pay to you a certain amount of money, which means not the same as your pre-disability income, but a percentage of your pre-disability income. If the policy has a percentage in it, it may be something ranging from 50 to 75%. If it doesn't have a percentage mentioned in the policy, we default back to the common law position, which could be something between 60 to 67% of your pre-disability income. In that instance, if you are able to work on a part-time basis and you're able to earn that amount of money, you may not be qualifying for LTD benefits anymore. Also, if you do go down the road of, I want to do this on a part-time basis for an extended period of time, the insurance company may say to you, well, we do not have partial disability benefits contained in our policy. So not to say that wanting to go back to work Is it a bad thing? Of course it is not. Wanting to work on a part-time basis? Yes, it is a good thing. But it depends on the language of the policy. There may be certain provisions that will allow you to do part-time work, but that income that you make will be calculated depending on the factor in the policy, which means it may not be a dollar by dollar offset. There may be a different calculation that is made. I know this may sound confusing, but it can become complicated. And what I would suggest again is that you reach out to us and have a discussion with us about what it is that your plan is. And most importantly, if you've got a copy of the policy, we can review it with you to see what the best avenue would be. And of course, if you do end up going to a part-time job, the insurance company may be looking at that to see, well, if you're able to do maybe 20 hours a week, what can we do to support you to gain further function to allow you to work more hours, which ultimately may mean that your claim will be denied. Because if you get to a certain point where you can earn a certain amount of money, as I've said, under the any occupation phase, you may be working yourself out of a claim. But again, you're welcome to contact us for more information. Ron has a follow-up question, says, thank you. When does the clock start for this timeline and how long does she have? At what point should she consider a lawyer? So at what point should she consider a lawyer? Remember what I said, we offer free consultations. So she may want to have a discussion now with a lawyer just to see what the situation is, what the options may be. The moment that a claim is denied by an insurance company, the clock starts to run. Now, it depends on which province you are in, and it also depends on whether benefits were paid. There's something referred to as a limitation period, and it depends on which province you are in, because you've hit the nail on there by this question, when does it start to run? Generally, it's 2 years, but the question is, when does it start to run? For example, in BC, if you have been paid for a certain period of time, then the Insurance Act provides that the limitation period, which is the time to pursue a legal claim, starts to run on the date the next payment would have been made. It also provides that starts to run on the date that you knew or ought to have known of the cause of action, which in other words would be the fact that your claim was denied. So generally what people would say, if there had been no claim, if there had been no benefit paid, that the limitation period starts to run on the date of the denial letter. Now, having said all of that, it depends very much on the circumstances and the language of the policy. Is it a good time to have a discussion with the lawyer now? Yes, there's no obligation to retain a lawyer, but there is a very, very helpful, it can be very helpful if she does have a discussion with the lawyer, because then she can decide how to proceed. She doesn't have to retain the lawyer ultimately. The lawyer can give her some advice and she can decide what option makes most sense to her, because her situation obviously is very individual to her, where somebody else may decide, I'd rather just retain a lawyer, let them take all of this over, I can focus on my treatment. The insurance company won't be bugging me anymore, they won't be dealing with me, everything goes through my lawyer, which is very helpful, and especially in cases where people are dealing with a mental health situation, so they can focus on their treatment and not have the increased anxiety of having to deal with the insurance company. Okay. Yusuf says, sorry. With my condition, I cannot do some of the assessments like physical. My doctor has in my report saying obsessive somatization, but still sent me for physical examination and blood test. What I have to do. Yusuf, these are very particular questions. Usually, I would say if a person struggles with their physical abilities, and if the doctor feels that a physical assessment, like a functional capacity evaluation, where the insurance company retains an occupational therapist to perform a functional capacity evaluation, which may be a number of hours, and sometimes it's done over 2 days. If the doctor feels that participating in that assessment or examination will create further risk of harm or poses the risk that your condition will ultimately deteriorate as a result of the exact testing, then you would want your doctor to put that in writing and send it to the insurance company so that they are aware that your doctor is not agreeing that you participate in this assessment. And if the doctor doesn't want to do that, then it does become problematic. You may want to reach out to a specialist if you have one. But ultimately, if you feel that it cannot be done, get your doctor on board, have the doctor write a letter, send it to the insurance company, and hopefully they will take a different approach. A. Brown says, if your condition has only a 60% survival rate, is that still eligible for LTD? If you are unable to recover and you are considered terminal, do you still receive LTD? I'm sorry, it sounds quite serious, A. Brown. This is what I will say in response. And it may sound harsh. A disability claim is based on functional impairment. If you have a condition, an illness, or an injury that prevents you from performing the essential duties of your occupation, if you're still in the own occupation phase, or the essential duties of any other occupation, if you are in that phase, the assessment remains that you have to prove that you cannot perform the duties of either your own or the any occupation phase, regardless of the illness itself. If it is terminal or there's only a 60% survival rate, obviously that's going to create some emotional stress. It's going to impact your mental health. So when you do submit a claim to the insurance company, or if it is already submitted and being paid and you're concerned that it may be cut off, at your end, see the doctors as regularly as possible. Report to your doctor your ongoing restrictions and limitations. If it is I don't want to use an example with respect to a specific illness, but if it is an illness that may worsen over time, obviously, what are the restrictions and limitations resulting from that illness? But also looking at the global picture, not just with respect to the actual restrictions and limitations because of that illness. How does it impact your mental health? Does it create anxiety? Do you have a generalized anxiety disorder now? Do you also have a major depressive disorder? Do you have panic attacks? Does it impact your focus, your concentration, your sleeping, your motivation, your energy, your fatigue levels? Have the doctor comment on all of those things when the insurance company adjudicates the claim. I feel confident, based on just with your question, that that would be the case, that your doctor would be in a position to write such a letter and to continue to support your claim. If you have a condition that, as you say, if you are unable to recover, are you considered terminal, and are considered terminal, do you still receive LTD? You receive LTD as long as you are deemed to be totally disabled, regardless of whether the condition is terminal or not. The assessment is, does the condition render you totally disabled because you are unable to perform the essential duties of your occupation based on the restrictions and limitations? And this is also, as always, very important so that you can have your doctors weigh in on this when the insurance company requests further information. For example, they may write your doctors to prepare or complete a form. That's what the doctor should be focusing on. What are the restrictions? What are the limitations? And of course, if your claim is denied, please reach out to us and we can have a discussion with you as to what your options may be. And as you can see on the screen, go to disabilityrights.ca. Hey, Brown, I hope that was helpful. If you've got further questions, again, just reach out to us. There's a question from I Know on YouTube. What about travel? Can someone travel while on LTD? I get asked this question so many times. So few things to be said. Nothing is ever an easy answer. Remember, the policy is a contract. The policy has rights, terms, and obligations. Some policies may provide and do provide that you cannot travel outside of the country for a certain period of time. Some may provide that you cannot leave the country for more than 30 days. And if you do, then you may be at risk, I suppose, of the claim terminating. But you can also speak to the insurance company about that and say, well, these are the reasons why I need to travel for more than 30 days. And then the insurance company can make a decision as to whether they will agree to that or not. Other policies are silent on this, meaning that there's no prohibition in the policy itself preventing you from travel. But is it as easy as that, is the bigger question. If the policy is silent on travel, remember, you're making a claim for total disability. So what you are reporting to the insurance company would be your restrictions, limitations, the reason why you cannot work. For example, if it is a mental health disorder, where you say you cannot travel, you cannot leave the house, you've got agoraphobia, you cannot deal with people, you're housebound, you have panic attacks, etc. Insurance company's policy doesn't provide that you cannot travel. Then you get on a plane and you go on a 3-week holiday. the insurance company is going to have significant questions about that, understandably so, because what you're reporting to the insurance company with respect to your symptoms, your restrictions and limitations should be consistent with what you do during your everyday life. This does not mean that you cannot travel. Should people stop living their lives entirely just because they're on LTD? No. Sometimes doctors recommend, especially during the winter months, for people with maybe chronic pain, where the cold affects their condition, or where the dark, cloudy days, gray skies may be impacting a person's mood, where it may be recommended that you go on a holiday to a sunny destination, or somebody may just want to go visit family who may be more supportive. So there may be various reasons why it may be recommended that a person should travel, as long as what you are reporting to the insurance company with respect to your restrictions and limitations remain consistent with what you're actually able to do. It really depends on your factual circumstances. But I can tell you this, I've had many clients who do travel while we're representing them through a legal claim. It depends on how much they travel and, of course, what it is that they are doing in terms of what their actual disability is. If you go travel 6 or 7 times a year and you go on holidays all the time, but you cannot work, the insurance company is going to question that. Steps 2 says, recently diagnosed with a progressive illness that will impact mobility. I'm not sure how to start the process. Do I need to be off work first to apply for my LTD? Should I wait to be non-functional? I've started to reduce my duties and work time per my doctor, but I still work. You have to be extremely careful here. You don't want to work yourself out of a claim. First things first, the policy will provide that you need to be actively at work, which is a defined term, in order to still have coverage. What I mean by not working yourself out of a claim or coverage really is the following. Your policy will require to be actively at work, that you have to work a minimum amount of hours. Let's say it's 20 hours a week. Let's say you've reduced your hours now and you continue to work on this basis. Then you may go below, let's say it is 20, below the 20-hour mark, and you work like that for over a year or more. The insurance company, and then you become disabled, meaning that you stop working entirely. The insurance company may say to you, well, when you stopped working, because that would be the date of disability, you did not have enough hours to qualify for coverage to even make a claim. So you want to be careful about that. You may want to have a discussion, and I think in your situation, you really should reach out to us so we can understand how many hours you are working, how many hours have been reduced, how long has this been going on, because you don't want to sit and wait and make the claim too late. No, you should not wait until you become entirely immobile. Just want to see what wording you used. Should I wait to be non-functional? Definitely not. The decision to make a disability claim, and if you're speaking about LTD, remember there's a waiting period. So first things first, have a discussion with your doctor whether your doctor supports that you stop working. If the doctor agrees to that, then you contact your human resources and have a discussion with them that you need to apply, I suppose, for benefits. There's a waiting period. Your policy or your insurer, your employer may have short-term disability benefits as well. For LTD, there will be a waiting period, whether it is 4 months or 6 months or even a year. It depends on the benefit package that you have with your employer. But it is crucial that you do not continue to reduce your hours and then miss the application. So it's crucial to understand what the ramifications of that are. In your situation, if it is a progressive illness, for example, it may be multiple sclerosis or something else, you want to understand what the definition for total disability in your policy is. If it is due to an illness or an injury, you are unable to perform the essential duties of your occupation, have that discussion with your doctor so your doctor understands what is at stake here. And if the agreement is that you should stop working or even try modified duties, consider where to go with that. In your situation, again, I strongly recommend that you reach out to us so we understand what the policy provides for, where you are at in terms of the progression of the illness, how many hours have you already been reducing, and what benefits are available to you, because you do not want to miss the deadline to apply as well. But definitely do not wait until you're non-functional. Remember, when you have a disability claim, and as you can see on the screen, you can go to disabilityrights.ca. When you have a disability claim, it doesn't mean that you have to be non-functional. It simply means that you have to be unable to perform the essential duties of your occupation. Lots of people are still able to work, even though they are on LTD, because they may be able to perform some rudimentary duties, but globally seen, they're unable to perform the essential duties of their occupation. A different way of referring to this is, or explaining this is, if you have a condition which allows you to perform some of your activities of daily living, your self-care, does that mean that you're not totally disabled? No. The question is, are you unable to perform the essential duties of your occupation? Then, I think we have one more question. I hope that was helpful. Question on YouTube from Alexandra. I'm currently off on STD, but my doctors have said that there is no way I can return to work in the near future. I need to transition to LTD, but I'm worried about talking to my insurer and saying the wrong things. How should I approach this? What should I do before speaking to my insurer? Well, the first thing is you need to be honest. As I'm going to sound like a broken record, you need to see your doctor regularly. You need to report to your doctor your ongoing restrictions and limitations, so that when you speak to the insurance company, you don't want to miss the timeline to apply, right? So you're on short term. If your doctor thinks you're not going to go back to work in the foreseeable future, then it needs to transition to LTD. Don't be afraid of that process. It needs to happen, but it's understandable that you may be nervous about the process. The insurance company, the case manager, likely will reach out to you to conduct what is referred to as a functional telephone interview. In that interview, they're going to be asking lots of questions like, what led to you stopping work? Were you unhappy with the circumstances at work? Were there any work issues? Because they're trying to establish whether the reason why you're not working is because of your disability or because of unhappiness with what was happening at work. They're going to be asking you questions about your activities of daily living. Do you do banking? Do you drive? Do you clean the house? Do you have any other supports? They're going to be asking you about your doctors. Who do you see? How regularly do you see them? Are you being referred to a doctor on a wait list, etc.? So lots of questions will be asked. You need to be honest, but also understand that they're trying to elicit from you evidence related to function. So when you respond to these questions, also think about the things that you cannot do. And what you report to them needs to be consistent with what your actual restrictions and limitations are. If you've got further questions, again, you can reach out to us. Okay, we've got 2 minutes left, and Laura just sent in a question, so I'll see if I can assist. Get through this one quickly. Laura says, worked for 19 years. I'm in sick leave from almost 6 months. And my intention is to apply for LTD. Could be terminated during LTD. What should I do if the case? Okay. I suppose the question is, could I be terminated during long-term disability? What should I do if the case will not be approved? So, good question. While you work, if you have long-term disability benefit coverage through your employer, you will have coverage. If you become disabled during the period of having coverage, in other words, while you're still employed, your claim vested then. If the employer then terminates your claim during the short-term period, you should be speaking to an employment lawyer as well about this, because there may be a claim against the employer, very likely will be. But with respect to the LTD claim, go through the process. They should not be denying you because your employment was terminated. And if they deny you, then you reach out to us and have a discussion with us to discuss what your options would be. Do not wait. There are certain timelines that you do not want to miss. And with that, quickly, that brings us to the end of today's session. Our next Q&A will be an employment Q&A with my partner, Samfiru. As you can see on the screen, that's tomorrow, which is September the 25th, 1 p.m. Eastern Standard Time, which would be 4 p.m. Pacific Standard Time. Thank you, everybody, for sending your questions. Until next time, have a good day.